A federal judge has ruled in favor of Donald Trump's request for an independent third party called a special master to review documents seized by the FBI in its search of Mar-a-Lago last month. Now, it's really important to note that when Trump's legal team filed their request for a special master 2 weeks back, they could have gone to the nearest federal courthouse in West Palm Beach, Florida. Look at the map here on your screen. You can see it here, and it's located just down the road from Mar-a-Lago. But they didn't do that. They chose instead to take their request to a court over an hour's drive up the highway 70 miles north in Fort Pierce, where the sitting judge is Aileen Cannon. And just to tell you a little bit about Judge Cannon, because this is important context for you to know. She's young, 41 years old. I mean, I'm 40, so she's my age. We're young. She's relatively inexperienced, and she was appointed to the federal court and the bench by former President Donald J. Trump. She was confirmed by the Senate over a week after Donald Trump lost the election in November of 2020. She's also been a member of the ultra-conservative Federalist Society since she was in law school. Shouldn't matter which president appoints a federal judge. I want to be clear about that. They're all supposed to be above politics and to make decisions based on jurisprudence. Their decisions are supposed to be impartial and based in the law. Everybody knows, like, the blindfold over Lady Justice, that's the whole thing. That's like what that's supposed to mean. But that's actually the problem with this ruling. A lot of experts are saying that Judge Cannon seems to perhaps maybe not have followed the facts and the law. And it's also clear that they went really out of their way to go to her courtroom specifically. Legal experts all around America are slamming her decision today, particularly the part of the decision that orders the Department of Justice to stop examining the documents it seized from Mar-a-Lago until the special master review is complete. Quote, an unprecedented intervention in a federal criminal and national security investigation. That's one law professor at the University of Texas. Quote, untenable. That's what a former Homeland Security official under President George W. Bush said about Judge Cannon's decision. And even a law professor at Cannon's alma mater, Duke University, where she got her bachelor's, blasted her decision as, quote, laughably bad. Here to break this all down with us is Carol Lam, a former U.S. attorney and an MSNBC legal analyst. So, Carol, what's your opinion on the ruling itself in terms of the law? What is her legal justification for this ruling?
Well, Zerlina, the opinion's a long one. It's about 24 pages, and a lot of it is spent justifying why the judge thinks that it's appropriate to appoint a special master in this case. And unfortunately, in terms of optics, as you've been describing the past couple of minutes, it does sort of put a finger on the scale in the sense of saying, well, he's the former president of the United States. And so what if there are leaks to the press? What if this? What if that? What about his reputation? And those aren't usually considerations that you see in a judge's opinion dealing with matters like this, discretionary matters with respect to whether to appoint a special master or not. So there are those optics. But what disappoints me about the opinion in particular, from the point of view of the prosecutors, is it just doesn't give enough guidance. It says a lot of things about why a special master is necessary, but when it comes down to brass tacks, it's not clear to me what the Justice Department is exactly supposed to do with respect to various groups of documents. There are some documents that I don't think really need to be looked at by a special master because there isn't any way that they are either personal documents or documents that could be attorney-client privilege or fall under the executive privilege exception. And so I think there's some clarification that the Justice Department is going to have to seek here.
So just a quick follow-up to that point. I mean, one of the things that the Trump side has been arguing is that, you know, some of this stuff is personal, it's my stuff. But it feels to me like even the detail originally about the Department of Justice returning passports, doesn't that demonstrate a good faith effort to return anything that they came across that was personal? And they've already said that they've gone through things and put to the side attorney-client privilege information. So again, I guess the question is, what's the point of the special master?
Right. And if the judge wanted to be ultra careful about all this, she could have said, and this is what I actually expected her to say, she could have said, well, look, there are 520 documents that the Justice Department says are maybe potentially privileged. And what that means is they came across a document that perhaps was on a law firm's letterhead. So they put it aside and they say, we're going to leave that for the taint team to look at. Or they might have seen a reference to, say, Rudy Giuliani. And so they say, well, he's one of the former president's attorneys. So we'll put that aside. Mm-hmm. It doesn't necessarily mean that it was an attorney-client privileged communication. The same thing for executive privilege. So I expected the judge to bucket some of these categories a little bit more and say, this is what I want the special master to look at: the potentially attorney-client privilege documents, the potentially executive privilege documents. But instead, she said he should look at all 11,000 or 13,000 documents. And let me tell you that in the white-collar crime world, there is nothing grungier than having to go through boxes of documents that have been seized in a search execution. You're just looking at boxes of things that people have randomly thrown in, and I'm talking about when the former president left the White House. They just threw things into boxes, and now the FBI has to go through, look, there are things, there are pictures, there are news articles, and now the special master is going to have to go through those for, in my view, no reason. So if I were the prosecutors or the investigators on this case, I would try to make this as easy on the special master as possible. I would categorize the documents. They've undoubtedly gone through and indexed every document in there and say, these are the easy ones. These are photographs. These are the easy ones. These are newspaper clippings. And that's the grungy kind of exercise they're going to have to go through.
I was getting a little triggered just then because I've never worked on a federal criminal investigation, but I have done corporate civil litigation in large law firms. And so I was the one, as the paralegal, surrounded by those boxes, Carol. So I was like, oh God, that's a little bit of a nightmare. Somebody's going to have to make a nice Excel spreadsheet cataloging or in the database all of these documents. Last question, what do you expect to happen next in this particular investigation? Obviously, the DOJ has a chance to appeal or respond, but do you think that may delay the investigation? How do you see the next couple of steps shaping up?
Right. And from your experience, Zerlina, you know how this goes. If the department decides to appeal this, it will take time. And I think that's what they're balancing right now. They're thinking, should we just go along with this process here? And at the end of the day, we'll see where we are. And then if we really have to appeal, we will. But now, to appeal to the appellate court is going to take time. Both sides are going to have to brief it. And the Department of Justice may say here, you know what, we're going to make a proposal to the special master, because remember, this judge, she has not abdicated authority to this special master. She is only delegating it, and it comes back again to her if and when the parties disagree on the special master's decisions, which they undoubtedly will in some respects. So which one is going to take longer? That's probably what the Department of Justice is trying to weigh right now. And at the end of the day, is the special master going to end up forbidding them to use materials that they really need to use? And that's the ambiguity here. There's no way that the special master should be looking at classified documents, because classified documents are not communicative documents in any way. And the judge said, we're not going to stop the national intelligence review of those documents. So that implies to me that the special master isn't actually even going to look at those documents, because they're not going to make copies of classified documents and give them to the special master. And then the special master would have to have top secret clearance. So that's all of those details are simply not answered in this opinion.
It's so fascinating to see, all of the arguments on both sides sort of shape up. But I think at the end of the day, I'm sort of a lay person looking at this, like, if Donald Trump wasn't allowed to have the documents, like, that's the government's position, why are we going to let a special master look at these documents? Like, if he wasn't even allowed to possess these documents himself, and that's sort of the whole premise of this entire thing. Carol Lam, thank you so much for being here and helping us understand the latest. Please stay safe.
Hi, I'm Zerlina Maxwell. Thanks for checking out our channel on YouTube. You can see more from Zerlina by clicking any of the videos on this screen, and make sure you subscribe below to stay up to date on the day's biggest stories. Thanks for watching.